Hello. Well, in tutorial 4 we did two main things. First was about reviewing the areas that you've been looking at between the end of the English legal system elements of the course and before you move on to European Union law. So we reviewed the principles of UK constitutional law, and the key topics to concentrate on are separation of powers, its justifications and how it operates within the UK system. Secondly, parliamentary sovereignty, and Dicey's 3 points are useful here, so do have a look at them in the manual. And thirdly, conventions, what they are defined as and your thoughts on why they are obeyed. Then there was principles of human rights. Again, key points here are the traditional versus the modern approach, the key provisions in the European Convention on Human Rights, and the particular rights that people have at arrest, being taken to a place of detention, and whilst being held. Look at the individual rights there and say make a table of those. On principles of criminal law, the key thing to concentrate is understanding that distinction between actus reus and mens rea, the key elements in a crime. On obligations, again we looked at contract. Key questions there are, is there a contract? And to come to that conclusion, you need to look at offer and acceptance, intention and consideration. What's in the contract, express terms, and those terms which statutes will throw into a contract, what is referred to as implied terms, and the remedies. And in tort, when we're looking just at the tort of negligence, those three requirements to establish negligence of there being a duty of care, a breach of that duty, and thirdly, that breach having caused the injury to the claimant. So having reviewed those, as I say, the emphasis needs to be on making sure that you can briefly summarise the key elements in those ideas. We then went to have a look at European Union law, which is of course going to dominate the next few weeks of study until we move into the complete revision phase. And this particular point in human history, we have within the next month European elections, so expect to see a lot about the workings of the European institutions. Don't believe everything you read in the paper, and do relate it back to what you're reading about the institutions, the way they work, and the way that rights are enforced by individuals within the EU. So I put particular stress, and this is so important because it's the sort of fundamental error that will cause a good essay to fail. And that's if there is a confusion between the different types of Europe. The term Europe is very inexact. It means a lot of different things in different circumstances. But the key thing that you need to do is make sure that you are completely sure of the distinctions between the European Union and the European Convention on Human Rights. The European Union involves a membership of 28 countries. It started in its development in the 1950s with just 6 countries and has grown to the present 28. We actually did an exercise where I invited people to list those 28. It's quite a lot to remember. But the importance of it is that later on, when you're facing problem questions, it is important that you know whether the rights of the person that you're being asked to describe depend on whether they are citizens of a country which is inside or outside the European Union. So something perhaps you can do today. Try and work out what those 28 countries are. There's lots of information on the internet about what they are. The court is the European Court of Justice, or more properly, the Court of Justice of the European Union. It meets in Luxembourg. We say the United Kingdom joins in 1973. And the European Communities Act is the relevant piece of legislation, the 1972 piece of law. By contrast, the European Convention on Human Rights was drafted by the Council of Europe, a much bigger organisation. Now, the number of members does change more frequently, but it's in the upper 40s. So double the size in terms of numbers of countries than the European Union. It was formed well before the European Union and its predecessors come into existence. This is the late 1940s, and in 1950 the convention is drawn up. Britain is in there from the start and plays a key role. The court meets at Strasbourg and is the European Court of Human Rights. And the involvement of that law with citizens is a slower process. In the initial years, the only way that you could enforce a right in under the European Convention was for another signatory state to take up your case. Then in the 1960s, we allow citizens to take their cases directly to the European Court of Human Rights in Strasbourg. And then with the Human Rights Act, at the end of the 1990s, you see the English courts having to apply. And it's the European Convention on Human Rights that has things like declarations of incompatibility. So do make sure that you are very secure in the differences between the two. As I say, it doesn't help when the news media talks about the European Court as if there were just one, or Europe has said this, not distinguishing whether the source is the European Union or the source is the European Convention on Human Rights. You, as a lawyer, need to know that distinction. And as I say, to apparently confuse the two can be regarded as a fundamental flaw in an exam or a TMA question. The history of the EU, you don't need to know great amounts of details, and you're never going to be tested on, which year did a particular state join. But make sure that in your reading, you can satisfy yourself that you've got a good, broad understanding of the way that it has developed from that European coal and steel community through to the establishment of the European Economic Community and Euratom, to the European communities, and through on to the European Union. So make sure you can briefly outline that development. Secondly, you need to know what the institutions are, where they are mainly situated, and what they do. Unlike the traditional way of saying, you've got the legislature, executive, and judiciary, in the European Union, the legislature involves both the European Parliament and the European Council of Ministers, which is a bit unusual. But as you're looking through your history and as you're looking at the institutions, ask about what are their purposes, what are their roles within the legislative process. And then we'll go on and we'll have a look at some of the rights and how they're enforced. But that will be the subject of the next tutorial. Finally, you've got a TMA 3, which is due in on the 14th of May. It's a question asking you to do statutory interpretation, but it is not a question about statutory interpretation itself. So answers which include lots of details, in fact, any details on the various rules, the golden rule, the mischief rule, and so on, won't be answering the question. And remember, relevancy to answering the question is a key criteria for which marking band you're in. And if there's lots of irrelevancies, it can only get the barest pass. So, not the principles of statutory interpretation, but it's an attempt for you to look at a statute and to interpret it. You're not expected to use outside materials, and again, comments in an ETMA which said, well, it was said in this case that it was said, that is actually going to get marked down. How do you prepare for it? Get used to reading statutes generally. Look at the meanings of words, ands and ors, and so on, and their significance. Look at common words that come up. Spend some time on the extracts, but don't waste time looking at commentaries because you're not going to be credited for it. One case is very important, and that's the case of the Queen and Gosh, the so-called Gosh principle, G-H-O-S-H. So do make sure that from your reading you have a good understanding of what that test is. Central to this is analysing offences. So look at the offence as set out in the statute. There are usually words like something is an offence if, and the offence is both named and its characteristics set out. And what you need to do, having looked at that, is to work out what those elements are and consider whether they are the wrongful act or whether they are about the state of mind of the individual. Is it actus reus? Is it mens reus? Do think these through. Don't just look at it and say, right, I think that's the answer, because sometimes you need to think a lot more deeply about which category it falls into. Practice is going to be useful before you do it. As I say, I look forward to reading your interpretation of statute in the next TMA. Thank you.